Hello everyone, thank you for watching this video, and I wish to welcome you to today's class, a series on the law of contract. We've been looking at the elements of a valid contract, and for today I want us to move on and look at the third element, which is called consideration. So once again I wish to welcome you. My name is Sostin Ngabirano, and I'll be taking you through this series for today. So for starters, for there to be a valid contract, there are certain elements that must be fulfilled. Like I told you, the starting element is an offer, but that offer must be accepted. But even in the presence of those two elements, you cannot talk about a valid contract being formed, meaning that there must be other elements, and one of them is consideration. Okay, so consideration simply means that there is some sort of a mutual exchange of promises between the parties, and some academic authors have called consideration as the badge of enforceability of a given contract, simply meaning that without consideration you cannot enforce any given promise. So what is this consideration that appears so important in contract formation? What is consideration in the eyes of the law? So let's look at the definition of consideration. There is an old case of Curie versus Misa, 1875, which defines this concept of consideration. And according to that authority, a valuable consideration is, in the sense of the law, may consist either in some right, interest, profit, or benefit accruing to one party, or some forbearance, detriment, loss of responsibility given, suffered, or undertaken by the other. And to take it further, looking at the Contract Act, under Section 2 of that Act, it says that consideration for a promise, where at the desire of a promisor, a promise or any other person does or abstains from doing, or promises to do or to abstain from doing something. That's how Section 2 defines consideration for a promise. We are going to break this down later as the discussion ensues. As you will know, that definition under Curie versus Misa doesn't seem to be the ordinary definition that any person could understand. But in simple terms, you can talk about consideration being the price you pay for a service or goods. So that exchange, that I have this item, then you're giving me the consideration. It may be money, it may be another promise actually. So it need not to be money. Even a contract that is based on a barter exchange may actually be valid. So I want us to distinguish between consideration and a condition. Now, consideration distinguished from a condition, I can give you a slight example which can help you, a simple one. If I say that A says to B that I will give you 50,000 shillings if you should come to Kalere, there is no contract but simply a gratuitous promise which is subjected to a given condition. Now, in that case, it is just a gratuitous promise and there is no consideration. So upon fulfilling that condition, you would receive the 50,000 shillings. To bring this closer, you need to look at the authority of Khalil versus Carbolic Smoke Ball Company, where in that case, which we've already considered when we are looking at a unilateral offer, the plaintiff had provided consideration for the defendant's promise by doing what? By using the Carbolic Smoke Ball. So you realize that in that particular authority, the catching of influenza was only a condition which entitled Mrs. Khalil to enforce her promise. But the consideration was the use of the Carbolic Smoke Ball. So I think that can give you a clear distinction between a consideration and a mere condition. Then let us proceed and look at the different types of consideration. One, there are basically two types of consideration, and one is executed and executory consideration. Now, for consideration to be executed, this occurs when one of the parties does whatever he or she is required to do under a given contract. In that situation, the party is said to have executed his or her side of the bargain. What happens when I say something is executed? Let's imagine you're buying something and you've agreed on how much to pay. So the moment you pay, then you've executed your part of the bargain, and that consideration will be executed consideration. Now, secondly, for executory consideration, executory, the way we hear the word, it refers to something done in the future. So executory happens where one or both of the parties promise or promises to perform an act or acts, but at a future date. For instance, if X promises to deliver a car to Y and the latter promises to pay the consideration 2 weeks after delivery, there we say that the consideration is executory because its fulfillment lies at a future date. Lastly, we are going to consider past consideration, and this one has may not be one of the types, because as you are going to see, past consideration may not necessarily be a consideration, but it's also another classification that I want us to consider. So what is past consideration? Now, when you talk about past consideration, the general rule is that past consideration is no good consideration. It's not good consideration. And I managed to pick out an example from a book of my former lecturer, now Professor Bentu Nomjisha, which he quotes in his book, Principles of Law of Contract in Uganda. And this example can help you probably understand this concept better. He says that if John traveled abroad and while he was away, Tom, one of his neighbor's sons, washed his car without any instruction whatsoever from John. So as soon as John returned, he told Tom, "Oh, you're a good boy. You are so kind. I surely will reward you." So the following day, Tom demanded UGX 20,000 shillings from John, but the latter refused to pay. So Tom wants to sue for breach of contract. He wants to sue John. So in that situation, Tom's consideration of washing the car, we say, is past in relation to the promise for the reward made by John, and therefore that consideration is not good. So any purported claim by Tom would definitely fail because his consideration is in the past. I hope that example helps you, but I've further illustrated this by looking at some legal authorities. Most of these authorities are old, but I know they will give you insights into the whole subject. So there is a case of Rascola versus Thomas, and in this case, briefly, in that case, the defendant had promised, it was a transaction to buy a horse, where the defendant promised the plaintiff that the horse which had been bought by him was sound and free from any vice. That wasn't true actually, as the horse appeared later was found out to have vices. But remember, that promise was made after the contract was completed. So when the matter went to court, it was held that since this promise was made after the sale had been completed, there was no consideration for it, and it could not be enforced. Okay. Another case you can look at is Remarkado. In that case, a promise was made in consideration of carrying out certain improvements to the property, and but the improvements that were carried out were done before this promise. So court again held in that case that that promise couldn't be enforceable because the work had been done before the promise was made. So I hope that those two cases can help throw some light on the concept of past consideration. And like I said, the example that I gave you of John and washing the car should be very instructive. There are further facts, detailed facts for Remarkado, but I would wish to refer you to the casebook by Ewan McKendrick. I believe we have a copy in the library. You can look at it, and that textbook, it discusses these authorities in greater details and to give you more clarity. Like I've said in my previous videos, I'm always available for consultations. Should you have anything that is not clear, please feel free to get in touch with me via email, or you can use WhatsApp text, and I'll be happy and glad to assist you. So let us proceed, and we look at the exceptions to the past consideration rule. In law we say that there is no rule which has no exceptions. There is always an exception for anything. So the general rule on past consideration that it's not good consideration has been qualified, and those qualifications were highlighted by Lord Scaman in the Authority of Pao-Un versus Lau Yi Long, 1975, Volume 3, All England Law Reports, at page 65. And in that case, Lord Scaman said that in the following circumstances, although consideration may be past, it will be good consideration. And he noted that where a service is rendered at the request of a promisor, then that service consideration will be good even if it is in the past. Okay, and there is an authority of Lampley versus Braithwaite, which I will want you to look at with regard to that particular principle. The second exception that was highlighted was that where a service is rendered on the understanding that payment will be made. You do a service, but there was an understanding, and that understanding sometimes has been held that it may be implied that payment might be made for the service. And there is a case of Re-Casse Patents, 1892, which is also discussed in the book by Professor Bentu Nomjisha, Law of Contract, Principles of Law of Contract in Uganda, and I'm very sure that we have copies in the library. If you don't have one, I have a copy, so I can lend you and you return it back to me. But those two authorities are ably discussed in that textbook. The last qualification or exception is that if payment would have been legally enforced had it been promised in advance, then a subsequent promise to pay a certain sum will be enforced. So you see that the rule on past consideration, this last qualification seems to water it down, because it brings in that whole aspect of anticipation. If a given contract would have been legally enforceable, then a promise to pay in advance would a subsequent promise to pay a certain sum would be enforced. The commentary there has been that probably that qualification waters down the whole concept of past consideration, to show that if I did something and ordinary payment would have been legally enforceable, but I've done it, the subsequent promise to pay, then the money would be enforced. You need to look at the commentary by Ewan McKendrick in his book Contract Law, Cases and Materials, where he discusses these exceptions in greater details. Now, the last one of these exceptions is found under the Bill of Exchange Act. Under the Bill of Exchange Act, specifically Section 26(1)(b), it says that an antecedent date which would normally be regarded as past consideration would be good consideration for a bill of exchange. For clarity reason, if you want to know what a bill of exchange is, I can give you an example. One of the easiest ones is a check. You know that a check may be handed over to you, but payment will be effected in future. So in circumstances where you've already performed your part and now you're demanding and they pay you by a check, the Bill of Exchange Act, Section 26(1)(b, says that although such an antecedent is normally regarded as past consideration, that consideration is good. I will invite you to look at that Bill of Exchange Act, and also you can look at the definition of the Bill of Exchange under Section 2 of the same Act. Those are basically the exceptions to the past consideration rule. But I want us to now move on. Let's move on and look at the rules, the different rules governing consideration. Remember, I told you consideration is the badge of enforceability of any given contract, because when you have an offer and you have acceptance, you have arrived at a consensus ad idem. Sorry about that, I got an interruption. You've arrived at the consensus ad idem, and now you need to give your contract this badge of enforceability. What is that? Now, one, consideration must move from the promisee to the promisor. This rule has a relation to the privity doctrine, which simply means that only a person who has provided consideration for a promise can enforce that promise. Secondly, consideration should be sufficient but need not to be adequate. Okay, this is a rule that always causes a lot of debate on the that what is sufficient versus what is adequate. Do I need to pay you amount that is equivalent to the value of what you're selling, or you can agree to something way less in value provided that it has some value within the meaning of the law? And courts have said that the law is not concerned with bad bargains except where a party alleges that there were vitiating factors such as fraud, mistake, duress, coercion, or undue influence. So it's not the role of court to consider your bad bargains regarding negotiations. I'll give an example on sufficiency versus adequacy. Now, I have a peppercorn here. This peppercorn was made by me out of a paper, and after making this cone, probably it gains some value, but if you put it on a weighing scale to see its value, probably it is let me say 100 shillings. 100 shillings. Then I also have a speaker here. It's a Bluetooth speaker. It's the one that interrupted us. I don't know, it connected to some device, but this Bluetooth speaker is probably worth 600,000 shillings. It's a JBL speaker, very good, and it's expensive. But I also have this peppercorn. What if this speaker was owned by John, and then John says, Sostin, give me this peppercorn in return for the speaker? Would that contract be valid? Do you think that this peppercorn is sufficient for as consideration for this speaker? And that's what section 20 subsection 4 of the Contract Act tries to elucidate. It says that the adequacy of consideration may only be taken into account by court in determining whether the consent of the promisor was freely given. So it re-emphasizes my point up that courts are not interested with bad bargains. So John can actually sell to me the speaker at 100 shillings, or give him a peppercorn for a speaker. A peppercorn is 100 shillings, whereas the speaker is 600,000 shillings. You can see the difference, but courts are not interested. And I wish to refer you to the case of Bone Katatumba and 3 others versus Shumuk Springs Development Limited and 3 others. That is High Court Civil Suit number 126 of 2009 on that concept. Let's look at this concept of sufficiency versus adequacy, clearly. Remember what I gave you, the two examples of the speaker and the peppercorn. That principle was applied in that case of Chappell Company Limited versus Nestle Company Limited, where chocolate wrappers from the defendant's chocolate bars were held to be good consideration. So the chocolate wrappers are equivalent to my peppercorn. These chocolate wrappers would be equivalent or similar to the peppercorn because their value is really minimal. But the concept of sufficiency still reigns supreme because courts are not interested in your bargains. They won't say, Association got a bad bargain, so we are going to cancel this particular contract. No. And there are other examples that you can look at. Mountford versus Scott, where £1 was held to be good consideration for an option to purchase a house. £1 is equivalent to about 5,000 Ugandan shillings. And if you know the cost of constructing a house, 5,000 can't even buy a bag of cement. Okay? So it means that if parties have agreed, there has been consensus ad idem, a meeting of mind, where there has been an offer which has been accepted, then it ceases being the role of court to intervene in their bargains. So that consideration is good consideration. Never mind that it may not be adequate, but in the eyes of the law, that consideration is sufficient. So as I conclude on this principle of adequacy versus sufficiency of consideration, I want you to note that the general rule is that consideration must have some value in the eyes of the law. Whether adequate, even if it's not adequate, then it does not concern the court. It will only be a court's concern, like I've highlighted under section 20, subsection 4 of the Contract Act, where the other party is claiming that there has been a vitiating factor. A vitiating factor like a mistake, fraud, undue influence, and many others. And those vitiating factors, basically, they vitiate or annul the mutual consent to the contract, or the free will to the contract. I know under the introduction you looked at the concept of freedom of contract, where, if I remember, one thing I used to talk about freedom of contract that courts held, there was a decision by Lord Denning, I don't remember the parties, but says where two adult persons of sound mind enter into a contract freely, then courts shall not intervene, in that kind of relationship, except of course if you prove that there was some vitiating factor. Either you entered into the contract by a mistake, you are coerced to enter into that contract, which is called duress. There was undue influence. You are unduly influenced by a person close to you, like a family member, or your dad, or your mother, or your guardian, and many other related vitiating factors in that. So that is it about sufficiency. What you need to note is that consideration must have some value. Like I said, this may have a value of 100 or 50 shillings, but that is value in the eyes of the law. Let's look in details at this second rule governing consideration, which says that consideration must move from the promisee to the promisor. So the rule that consideration must move from the promisee basically means that a party can only successfully enforce a promise if it is proved that he or she provided consideration in support of that promise. And it has been said, like I noted earlier on, that this rule is contrary to the rule of privity of contract, which simply provides that only parties to a contract can sue on it. If you're not a party, then you cannot. So a contract is primarily a matter between the contracting parties who have provided consideration. What does it mean? Let me give you an example. Today, if I decided to buy for my son a car, and I went to one bond in Nakawa and I purchased, let me say, a Toyota Passo for him. It's a small car, consumption is very good, and I give it to my son. Then when I give it to my son, he later discovers that this car is fundamentally flawed because its engine is dead. It cannot move. So my son is aggrieved, and now he wants to take on the bond, the company that sold to me the car. Let me say it's XY Automotives Limited. So my son's claim will fail because he has not provided any consideration for that particular contract. It would be only me to claim from XYZ Automotives Limited because their contract was made between me and them, and I'm the one who provided the consideration. So the third party, who is my son, may not be able to enforce that particular contract. Okay. You look at that case of Prince versus Aston, which is couched in similar terms, and it will give you details on how this principle of consideration moving from the promisee to the promisor operates. There are other cases like Tweedle versus Atkinson. Probably I could give you some insights into this case. Now, in Tweedle versus Atkinson, there was a couple, and this couple intended to get married. So their fathers, the father for the bride and the father for the groom, made a promise to their children that they would give them certain amounts of money. I think one was 100 pounds and the other one was 200 pounds respectively. So after the marriage, these parents put this promise in writing. Okay, but unfortunately the father-in-law to the plaintiff died before paying his promise of 200 pounds, and then the plaintiff sued the executors to recover the money. Now, executors in law, when someone dies and they have left behind a will, the person or persons who are executing the will, we legally call them executors. If you die without a will, the people who distribute or manage your estate, we call them administrators or an administrator. So in this case, the father-in-law had left a will, and then the plaintiff was claiming from those executors who are executing the will or managing the estate of the father-in-law. However, court held that the plaintiff's action would fail since he had not furnished any consideration to the promise. Remember, the promises were made between the parents, so the children who are getting married weren't parties to this particular contract. So they could not wake up and say, we are going to enforce the contract which was entered into between my dad and your dad. That's, I'm referring to the bride and the groom. So that contract would, whether their claim, that the plaintiff's claim failed because he was a stranger to the contract, and as such he could not take advantage of it even when it was made for his benefit. Please look also at the case of Dunlop Pneumatic Tire Company Limited versus Selfridge, still on that same concept. A very interesting authority, but it's in line with Tweedle versus Atkinson on the concept of consideration moving from the promisee to the promisor. And further discussion on this concept, we shall look deeper into it when we are looking at privity, the privity doctrine under the law of contract. Before we sum up, I wanted to highlight a few aspects where, in the eyes of the law, those particular transactions have no value, and as such, they are not good consideration. These include performing a duty that is imposed by law. If you perform a duty that is imposed by law, let me say someone steals my speaker, the one I showed you as an example with a paper cone, and then a policeman arrests him. Let me say I lost that speaker, then I put up an advert that whoever finds it will be paid 100,000 shillings because of its value. Then a policeman nearby at a nearby police post finds that speaker, and he's claiming for the price that I had advertised. Now in that case, we can say that the police officer was performing a duty that is imposed on him by law, and as such he's not entitled to that, because what he gave is not good consideration. Basically, finding the thief was within his duty that is imposed by law. Then in some cases, some people may make or perform a duty that is existing contractually, basically performing an existing contractual duty. That is not, as a general rule, good consideration, but these two aspects have been subjected and discussed, and a number of exceptions have been developed. So, excuse me, we shall look at those different exceptions in our later discussion in details, looking at them and the exceptions that have been developed. Can a policeman performing his duty be entitled to a prize, like I had advertised in the, either on radio, when he finds something that was lost? We shall see that, and I will refer you to a number of cases in our later videos. Before I take leave of this matter, I want to please emphasize the fact that you need to do reading primarily and read these primary materials. Besides the cases, please remember to use some of the textbooks. One of the books that I would recommend for this particular topic, you can look at the Principles of Law Contract in Uganda by Ben Chiromba Twinomugisha. Like I said, we have copies in the library, so you should be able to access them. And if you have some money, please, you can get a copy from the bookshops in town. It was a pleasure watching, and I look forward to meeting you in our interactive classes. Please keep safe and see you soon. Bye-bye for now, and wait for my other videos on the concepts that are to come. This recording shall be uploaded on my YouTube channel for ease of access. Please like, comment, and share where necessary. Bye-bye.